Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today, I would be covering up the topic called what are patentable and what are not patentable under Patents Act 1970, which is there in SYBCom SEM 4 of Mumbai University course, and the same topic is there in FYBMS SEM 1 under the subject called Business Law. What is patent? Patent is an exclusive right granted to anyone by Government of India or any authority which is issuing patents worldwide, who invents new or improved products or process by the government. Patents provide protection for the inventions to the owner of the patent. The patent has been granted for at least 20 years. What do you mean by patent? Is that those persons who are inventing a new product, for that particular research work, whatever the amount they had invested, they want to get it back, and they had put up their efforts, and for that efforts they would be going to this patents office, that is IPR office, and they would be asking for patents, and the government would be checking out their credentials. Based on the merits, they would be issuing your patent certificate, and the validity of the patent certificate is for 20 years. Students, please be clear that there is a difference between patents. There is a difference between the discovery and inventions. For the inventions, only the patents are being given. For the discovery, patents is not being granted. Patent protection means the inventions cannot be commercially made, used, distributed or sold without the patent's owner's consent. So the consent of the owner of that particular patent who is holding that particular product is necessary before it makes working or before the product has been sold in the market. What are the objectives of the patent? To provide protection for the creativity of the creators. In this coming era, in this digital era, many people are inventing a new product, which may be useful for those mass public or which may be useful for the worldwide public. For those particular inventions, they will go to this authority and they will be asking for the patents. And once the patent has been granted, then that particular person would be having the exclusive right for over that particular research work or the new invented product. To promote the creativity of new creators. Students, in this particular point, I like to inform you, when the patent has been granted to the inventors, so there would be something like promotion, something like efforts are being recognized by government, and based on this, the other peoples who are inventing the new products, they would be also getting that particular information that they would be also in the habituated of creating new in research products. It also accelerates the technological and industrial development of the countries. So if you see in this last era, a few months back, when this new vaccines came into India, so in that particular cases, the injections, the vaccines, they had taken the patents from that authority of India, like Covaxin or the Covishield vaccines, that they had invested a huge amount of rupees for the discovery of that, the invention of that particular injections or that particular vaccine. So after getting the patents, the products came into the market and they charge some X amount for that particular vaccine. So if you see, the patents would be given for different types of inventions which is the creativity of that particular persons, and those persons who are having the habit of creating new products, they will go to the patents office and they would be going to the patents office and registering their products. It provides exclusive right. That means that particular person who is the owner of the patent would be having the exclusive right over that product, and he can charge some extra amount over and above the price to come out with that particular amount what he had invested for that research work. For the inventions and affords the protection against the unauthorized use of the invention by the third parties. Once the patent is been granted by the Government of India or the IPR office, he would be having exclusive right, and that he has the right to charge that amount, and he can be protected also by the government. What are the requirements must the person satisfy to get the patent? Here are the steps. The invention must be useful purpose, it should be useful for many purpose. It should not be useful for individual, it should be useful for the mass public. The invention must meet the legal definition of the novel process. If the idea is novel, if the process is novel, then only the patents would be granted, otherwise it wouldn't be granted. Understand the legal definition of the novel process, not the English definition of the novel process. Invention cannot be something that anyone could invent. It could be through the hard work of that particular researcher. He had investing his time, he is investing his energy, he is using his time for the research over a span of time, and in that particular purpose he is inventing a new product. For that invention he would be applying for the patents. The invention must have patentable subject matter. The matter involved in it should be patentable. So the disclosure has to be mentioned before applying to this patent office, why he wants to get his patent protected, why he wants to get his product protected, and it should be covering up this legal definition given under the Patents Act. What are the main categories of the patent? Coming to the first part is called the plant patent. It is the rarest type of the patent. The plant patent would be called as the rarest type of patent. Unless you are a botanist, you are unlikely to get this patent rights protected. These patents are of special plants that a person can reproduce asexually, not by sexual method. It should go for asexual method. Once the person owns the patent, he or she can decide if and when others can reproduce the plant. So it is the discretionary power of the botanist who has applied for the patents and who has received the patent. He can ask them when this particular product, when this plant can reproduce. It is for this powerful plant type of varieties of the patent is the scope, but it is of rarest kind, and the plant patent lasts for 20 years from the date of issue of the patents certificate. The other kind of patent are utility patents. The inventor receives the desirable patent for his creating a new item or a process. When a person proves that something is useful, he or she might receive the utility patent. So it is the IPR office to get themselves satisfied from those persons who are applying for that patent, that is this particular product is useful for mass. So in that case it would be called as utility patent. It gives the inventors control of the invention. No one else can use it for set time unless the owner allows it. That is the unique conditions under the utility patent. The utility patent once again is lasting for 20 years from the date of the application. Once the patent expires, the invention can enter into public domain and any other persons can produce same type of products. The logos, the designs, patents are the different types of utility patents, and it is lasting for 14 years. In this case, utility patent, this particular image which has been shown of that particular shoes or the lace is called utility patent, and it has been granted in the international market. Coming to the design pattern, you are aware there are many designs available in the bottles for the cups, saucers, or the watches, or any of the cell phone designs, or any of the cameras, or any of the tube lights, or any of the lights. There would be designs including the saris design, or any of the designs of the circuit board. So design pattern, an inventor who adds a distinctive element to a manufactured item might qualify for a design patent. So he has to add something unique for qualifying for the design patent. The inventor must introduce an ornamental feature or create an entirely new design. It can be the design related to paintings, it can be design relating to ornaments, jewelries, or XYZ products. A good example is of Apple product. Many of them have distinctive appearance and design. They also include new technologies. Design patents also last for 14 years. In this particular image, if you see, these are the image of the dials of the watches, and they are getting that design patent from the international market. What is patentable and what is not patentable? Coming to the point, first of all, I would be explaining in this particular slide what objects can be patented. Patentable items include new products, the first important criteria, processes, different type of processes involved in the manufacturing activities, and the ideas for a utility patent. Existing ideas featuring new design for a design patent and generally designed plans for a plant patents. So for plant patents we have a uniqueness, that is genetically designed plant patents is mandatory. A person or a business can earn a patent in many fields of innovations. A government wants to reward inventors. They uses patent to encourage innovations and creativity. So government of India accepts such type of applications who are creating new and new products, and those who are using some amount, some funds for the research activities which would be useful for India as well as for the mass public. So they are rewarding and encouraging by giving them the patents right. Which subject matters are patentable? An applicant can receive the patent in categories such as business processes, computer software that are useful, concrete and tangible purposes. Computer hardware programs are also patentable. Electronic items, goods are also patentable. Fabric and fabric based designs are also patentable. What subjects are patentable? Coming to the next criteria, the human genes that meet certain specific or scientific requirements are also patentable. Man-made but not naturally occurring bacteria are also patentable. So something new is that man-made bacteria are also patentable. The medicines which have been discovered in this coming era, which will be discovered, which are in the research process, when they apply for patents, the government of India can accept their patentable rights for the medicines or the other products related to medicines, or the instrument related to sporting equipments, including the equipments which are there in the gyms. What is not patentable? This is the important particular slide where the students should understand. Mere discovery. What do you mean by the term mere discovery means? And by an accident something is been discovered. So such type of discoveries are not acceptable by government of India, because it is any person can discover by the naked eye, or any person when he does such type of research can go for the discovery, but such type of discoveries are not been patented. Only the inventions are been patented. It is mere discovery of something that is already existing freely in nature is a discovery and not an invention, and hence cannot be patented unless it is used in the process of manufacturing of an article or a substance. So students, please be clear with the word discovery and invention. Only these particular products or the goods which have been invented are patentable. These discoveries are not been patented. For instance, the mere discovery of microorganism is not patentable under the Patents Act. Which substances are not patentable? Frivolous or against the established of natural law. So thus those goods, those items, those products which are against the law, or those who wants to harm the other peoples or other societies or to the sovereignty of India, such products are not patentable. Harmful to human and animal health would be also not patentable. Those goods which would be harming to the human being or to the animal are not patentable. Scientific principles of formulation, mathematical formula or algorithms in the computer programming are not patentable, which can be done by any person. The discovery of new properties of a substance already known in a chemical formula or in a chemical substance, in a product or a reaction when it is going on. So such type of new properties of the substances are not discovered, are not patentable under the chemistry laws, and it is not accepted by the IPR office. The next criteria is that the substance obtained merely by combination of two already known substances. Whenever two substances are mixed in different combination as 1:1 or 2:3 or 3:1 or 4:3, and such type of combinations are not patentable. Method of agriculture or horticulture are also not patentable under the new Act of Patents. Rule or method of performing mental act or playing games are also not patentable under the Patents Act. Students, in this particular video, I had explained you what do you mean by patents, what are patentable and what are not patentable under the Patents Act, and this particular topic is in SYBCom SEM 4 of Mumbai University, as well as in first year BMS of SEM 1 of Mumbai University under the subject called business law. Thank you.